Good morning, everyone. Greetings and welcome to today's webinar, Attention Multi-State Employers, State Employment Laws Ripe for Change, presented by Quarles and Brady. My name is Otto Immel, and I lead our Florida Labor and Employment Group. Over my career, I have counseled and represented employers in a wide variety of workplace-related litigation. I advise HR professionals in all levels of management on myriad workplace decisions and practices, including workforce management issues involving the Family and Medical Leave Act, the Americans with Disabilities Act, and other federal, state, and local fair employment and anti-discrimination statutes, compliance, immigration, and workplace investigations. I also provide training sessions for my clients on topics covering all areas of labor and employment law. I am very pleased to be with you today. Before we begin the presentation, we have a few housekeeping items to go over. We will be applying for 1 hour of CLE credit. If you are an attorney and would like to receive CLE credit for attending today's program, please fill out the CLE form located at the back of the materials found in the handouts panel of the webinar dashboard. Please complete the form and return it to the contact listed at the bottom of the document. There is also an HR attendance certification form in the dashboard materials for human resource professionals to use in self-reporting. We have muted all phone lines for those dialing in and for participants listening to audio via computer, so you will not be able to speak. We are in listen-only mode. We would like you to be aware that this presentation is being recorded and an electronic survey will be emailed to you after the program. If any webinar participants have a question, please type your question in the chat box located in the upper right corner of the webinar dashboard and submit. Every effort will be made to answer questions near the end of our time together today. A recording of the presentation and the PowerPoint slides will also be available after the presentation on the Labor and Employment Events tab at quarles.com. So today we're going to be talking about the increasing trend of employment law regulation at the state level. The driving force behind the state's actions has been inaction by the federal government, and in fact, a reversal of positions in several important areas that has led states to move forward with protecting workers within their jurisdictions. In addition, last year, the Me Too movement increased the publicity of sexual harassment claims, and that has led states to change the way companies litigate, settle, and disclose claims of sexual harassment. So the major areas that we're going to be covering today are state changes to minimum wage laws, state increased minimum salaries to be exempt from overtime requirements, state requirements for anti-harassment training, prohibition of confidentiality clauses in settlement of sex harassment claims, prohibition of requiring arbitration of sex harassment claims, non-disclosure and waiver provisions in employment contracts that prospectively limit or preclude disclosure of sex harassment claims, and some other changes to the interactive process at the state level, and some state-specific laws that are a little out of the ordinary, including time off for victims of crime and permissive changes of schedule due to personal events. So we all know that the federal minimum wage came about as a result of the Fair Labor Standard Act, which is now more than 80 years old. The initial minimum wage in the United States was set at 25 cents per hour and was in effect in 1938. Over the years, there have been many increases, and listed here are the most recent increases. And what is of note is that there has not been an increase in the federal minimum wage since 2009. So we're almost 10 years into the minimum wage at the federal level. Due to this lack of action on the federal level, states have taken the issue into their own hands and implemented increases at the state level. We have 29 states that have minimum wages that are higher than the federal minimum, and 21 of those states are increasing their minimum wage for 2019. I will not read every one of these states, but as you can see, they range from a low of $8.46 in Florida, up to a high of $14 in the District of Columbia, with a number of states clustering in at $12 per hour. In addition to increasing the minimum wage, many cities and municipalities have even higher minimum wages that are in excess of the state minimum, and some jurisdictions assign minimum wage based on the size and location of the employer. The takeaway on this issue is that if you have minimum wage workers, you should be checking both the state and locality in which they are employed to make sure that you do not run afoul of a higher minimum wage. In addition, under both federal and state law, employees who work over 40 hours per work week are entitled to overtime pay unless they are exempt. And part of the exemption test is a minimum salary requirement. That has been set at $23,660 annually for more than 10 years. As you may recall, there was an effort to increase that to about $46,000 a couple of years ago by the outgoing administration. That effort was struck down by a federal court last year, and we are anticipating a new regulation from the Department of Labor that was calendared to be released in mid-March. Whether that will be delayed due to the government shutdown is not known at this point. But at the federal level, we are still at a 10-year-old salary basis requirement. So some states have enacted their own minimum salaries. New York, for example, has, as of December 31st of last year, a requirement that employers in most of the state must pay at least $43,264 to have an exempt employee, and that goes up to a high of $58,500 for large employers, meaning those with 11 or more employees in New York City. Similarly, California has a standard that requires the employee to be paid at least twice the state minimum wage based on full-time employment. And their minimum wage is set to increase annually over the next few years. This is for all employers in California. This chart lists the year and the sizes of employees required to trigger the different standards. As you can see, as of this year, it is a low of $45,760 for employers with fewer than 25, and in 3 years, it would go up to $62,400 for employers with 26 or more employees. So again, a lot of activity at the state level on the notion of exempt employees, something to keep an eye on. With regard to anti-harassment training, many states have enacted laws requiring particular anti-harassment training by employers. Right now, the list includes California, Colorado, Connecticut, Maine, New York, and New Mexico. And some states have requirements for state workers, and all states either recommend or encourage training but do not require it. So what is required in some of the states with specific training requirements? In California, the training is very specific. The requirements are very detailed. The rule for companies with 50 or more employees is to provide training to all supervisors within 6 months of hire or promotion into a supervisory position. Those people must be retrained every 2 years. The training itself must be effective and interactive, which means that it has to be live training, whether that is by webinar or in-person training. It has to be interactive so that the participants have an opportunity to ask questions and to answer questions. The new requirement as of last year includes coverage of anti-harassment focusing on gender identity, gender expression, and sexual orientation. In Connecticut, companies with 50 or more employees must provide training to all supervisors within 6 months of hire or promotion. They are encouraged to retrain every 3 years, but not required by law to do so. The training must be at least 2 hours long and must include experiential exercises and discuss the perpetual and communicational differences among all persons. So again, some specific requirements for employees in Connecticut, such that a sort of generally applicable harassment training may be insufficient. In Delaware, employers with 50 or more employees must provide harassment training to new employees within 1 year of their hire and to existing employees within 1 year of the effective date of the act and every 2 years thereafter. In Maine, the requirement is for any employer with more than 15 employees. And the law in Maine requires that they be, that the training covers sexual harassment and take place within 1 year of the commencement of employment. Supervisors and managers must get additional training within 1 year of assuming their positions. New Mexico requires primary and secondary education providers, so both government and private entities, to train all school personnel at least once a year. New York has a very newly enacted, as of October 19th, requirement for all employers, regardless of size, to give annual sex harassment training and have a written sexual harassment policy. The content of that policy is also set forth in detail and generally varies from the standard policy that you often see in employee handbooks or sample handbooks, and has some specific requirements particular to New York that have to be covered. The legislation has a model policy, but the model policy it may not fit within the theming of an employee handbook, and so should be reviewed carefully before being adopted. Still on the topic of the Me Too movement and related legislation, at the federal level, the tax law changes at the end of 2018 contained a provision prohibiting employers from taking a deduction for attorney's fees and costs incurred in any sexual harassment or sexual abuse case if the settlement agreement includes a non-disclosure provision. We are awaiting further regulatory guidance as to the total scope of that, and again, no great expectation that that's going to be forthcoming anytime soon, given the current state of affairs in Washington. California, not surprisingly, is another leader in this area, and as of the first of this year, has ruled that settlement agreements, including provisions precluding an individual from disclosing factual information related to claims of sex assault or harassment or discrimination, will not be permitted. The claimant can request such a confidentiality provision, but the accused has no similar protection. The amount of a settlement can remain confidential, but the facts relating to the claims cannot. In New Jersey, there is currently under consideration legislation that would ban the use of confidentiality provisions in any settlement agreement that attempts to conceal discrimination, retaliation, or sex harassment. If the employer includes a confidentiality provision, it must include a prominent notice that the clause is unenforceable. Again, this is not yet the law, but it is progressing in the New Jersey legislature. In addition, it prohibits retaliation for refusing to sign a non-disclosure clause. In New York, Confidentiality clauses in settlement agreements relating to claims of sex harassment are prohibited unless they are preferred by the complainant. And I see in this slide that there's a typo that will be corrected when the PowerPoint is posted. It requires a 21-day consideration period and 7-day revocation. So just like the requirement to obtain a valid waiver for an age discrimination claim, to the extent an agreement is proposed that would contain confidentiality provisions in New York. Staying with New York, arbitration clauses relating to sex harassment are prohibited. This is contrary to the expanded use of arbitration agreements that has recently been approved by the U.S. Supreme Court and the general preference for non-court resolutions. And a number of states, as we will see, have followed this idea. And so mandatory arbitration in New York cannot include sex harassment claims. Again, in New Jersey, pending legislation makes any provision in an employment contract that waives any substantive or procedural right or remedy relating to a claim of discrimination, retaliation, or harassment unenforceable. So this would go beyond an arbitration provision and would render unenforceable a wide variety of mechanisms for alternative dispute resolution or waiver of jury trials or some other form of alternative dispute resolution. In Vermont, the prohibition is on employment agreements that require claims of harassment to be resolved through arbitration. So similar to New York, California kind of provision. Washington voids the ability to enforce contracts or agreements that waive an employee's right to publicly file complaints regarding sex harassment and sexual assault. In Maryland, effective October 1st, a new law precludes provisions in employment contracts that waive rights to future claims of sex harassment or retaliation for reporting sex harassment. It's not clear exactly what the purpose of that law is because it's generally not possible to waive claims that have not yet occurred. But there's another part of the Maryland law that we'll talk about in a second. In Tennessee, a new legislation prohibiting the requirement that employees or prospective employees be required to sign or renew non-disclosure agreements regarding sex harassment in the workplace as a condition of employment. Washington State prohibits signing non-disclosure agreements regarding sex harassment and sex assault as a prerequisite for employment. So again, carving out of what would be generally applicable and permissible agreements between an employer and an incoming employee to modify the form and venue in which claims can be brought. And this is something that is ongoing and under consideration elsewhere as well. Maryland, we're coming back to, in addition to the prohibition on the waiver, is requiring mandatory disclosure of harassment in the workplace. It requires employers with 50 or more employees to disclose the number of settlements made after sex harassment allegations, the number of settled allegations of sex harassment against the same employee, and the number of settlements of sex harassment that included non-disclosure provisions. These the reports are to be made in 2020 to the Maryland Commission on Civil Rights, and the aggregate information for the employer will be posted on its website, and the individual survey reports will be made available by the Commission upon request. So that's quite a broad and far-reaching requirement in Maryland, and employers with sufficient employees and operations should be taking this in due care. All right. In another area of expanding protections for employees, we're going to talk a little bit about employment applications and pre-hire information. And we'll start by talking about criminal history information. These are the questions that were typical on employment applications that had some variation of if you have been convicted or pled no contest to a crime or to a felony, you had to disclose that as part of the initial application process. This, over the last few years, has come under increasing scrutiny, both at the federal level with the EEOC's guidance on the proper treatment of criminal history information, and on the state and local level with the short name of ban the box. This is the restriction on whether you can ask or at what point you can ask an applicant to disclose prior conviction information. Presently, 31 states have statewide laws or policies regarding inquiries into an applicant's criminal records until sometime later in the hiring process, not the initial application. The idea being that this will give people a fair chance to have their skill, ability, experience, and credentials considered before the information about a criminal history comes out. And the momentum for this has grown exponentially in the last couple of years. So far, presently 11 states have mandated removal of conviction history questions from job applications, those being California, Connecticut, Hawaii, Illinois, Massachusetts, Minnesota, New Jersey, Oregon, Rhode Island, Vermont, and Washington. In addition, other states have imposed that requirement on state or local contractors. So people who are doing business with a state or locality may have a restriction on their pre-employment criminal history inquiry. And more cities and states are considering this all the time. This is another area that is rapidly evolving and is one that is worth monitoring if an employer decides to continue to ask the question in the initial application process. And so if you do not have operations in any of the states where it is improper to do so, you still should be keeping your eyes open for additions to this list. In another area of application restriction, in the last year or so, there have been a number of states that have restricted asking about an applicant's salary history. The idea being that to a certain extent, it is considered to perpetuate what might have been underlying discrimination from years ago if applicants are required to sort of live with their salary history as they move from one employer to another. So salary history is prohibited in Massachusetts, Connecticut, and Hawaii. California provides that prior salary alone cannot by itself justify a pay disparity, but doesn't provide quite as high a level of protection as the other three states. Cities with restrictions include New Orleans, New York City, Philadelphia, and Pittsburgh. This is an area that is again, rapidly developing and gaining greater traction. So the following states are actively considering passing laws that would restrict inquiries into salary history. And it's a pretty substantial list. There are 18 additional states where this is under consideration. And so it would be prudent to take a look at these states if you have operations to make sure that if the laws are enacted, that your application and interview practices are in keeping with the restrictions. Because, you know, it has been traditionally common to ask for prior compensation as part of an application work history section. And employers do find it relevant to establishing whether the range for the position they have in mind is likely to be too low for a particular candidate. Again, if you're operating in one of these states, flag it and keep up with any additional requirements. Turning now to family leave, the baseline federal act is, of course, our old friend, the Federal Family Medical Leave Act, which is 12 weeks during 12 weeks of unpaid leave during a 12-month period for certain covered reasons, care for a newborn, adoption, or foster child, and applies to employees of 50 or more. Other states, and again, this is unpaid leave. Paid family leave so far is in effect in California, New Jersey, New York, Rhode Island, and Washington State. And the states take a different approach to the paid family leave, and we'll go through those just to cover some of the approaches. In California, to be eligible, an employee must have worked for an employer for at least 12 months and have 1,250 hours of service during the 12 months prior to the leave. So that's the same as the FMLA requirement. They receive in California up to 6 weeks of paid leave to care for a seriously ill child, spouse, parent, or registered domestic partner, or to bond with a new child. And the amount they receive is about 55% of their weekly wage during that 6 weeks of paid leave. This is funded through payroll taxes. New Jersey's paid family leave applies to employees who've worked 20 calendar weeks or who have earned at least 1,000 times the state minimum wage during the 52 weeks prior to the leave. They receive up to 2/3 of their wages, up to a maximum of $524 for the 6 weeks of paid leave. This paid leave would run concurrently with federal FMLA or New Jersey family leave, which have some areas of overlapping coverage, but not complete overlapping coverage. And so New Jersey is a complex state to administer leave. New York has recently enacted a broad paid family leave for all private employers who are for employees who are full or part-time and who work 26 or more consecutive weeks for a covered employer, and public employers can opt in. The maximum leave allowed during a 52-week period increases annually, and it started with 8 weeks, and as of this year, it is 10 weeks. The maximum benefit is 50% of the lesser of the employee's average weekly wage or the state average weekly wage. And it increases this year to 55% and next year to 60%. Paid family leave in New York is very broadly available and has led many employers to seek some outside administration for eligibility and benefits determinations. And so this has been an area that for insurers has been a new area of coverage, but one that has led to a number of questions as the regulations in New York are not as thoroughly developed as the fine questions require. Rhode Island provides paid family leave to all private sector employees and public sector employees whose employers have opted into the program. The benefit is less in Rhode Island than in some of the other states we were just covering, providing 4 weeks of paid leave for birth, adoption, or fostering of a new child, or to care for a family member with a serious health condition, and up to 30 weeks of paid leave for a worker's own disability. So a different approach in Rhode Island. The maximum benefit is quite high, $750 per week, based on the employee's earning, and is again funded through payroll taxes. Washington State requires employers to provide 12 weeks of paid time off for the birth or adoption of a child, or for the serious medical condition of the employee or the employee's family member. Some states have requirements for paid sick leave for state employees. These include Arizona, California, Connecticut, Maryland, Massachusetts, New Jersey, Oregon, Rhode Island, Vermont, Washington State, and Washington, D.C. So public sector employers in those jurisdictions have a paid family leave requirement. School-related parental leave has become an increasingly common thing to see in states, and the following have enacted legislation allowing parents leave to participate in children's educational activities. So again, no surprise to see California, Massachusetts, leading in this area, but in addition, we also have Colorado, Washington, D.C., Illinois, Louisiana, Minnesota, Nevada, North Carolina, Rhode Island, and Vermont. Again, not an area that is terribly common for employers to have to comply with, but if you have operations in those states, it would be very easy to run afoul of this if the supervisor or location manager denies a request for leave that is statutorily available. So we've seen some recent changes to the interpretation of sexual orientation and gender identity discrimination. In Michigan, the governor's issued an executive directive barring state employers from discriminating against public employees and applicants on the basis of sex, which is defined to include sexual orientation and gender identity or expression. And in Wisconsin, an executive order January 7th banned discrimination against state workers on the basis of sexual orientation or gender identity. Some less common forms of legislation in New York City, as of May of last year, employers in the city must allow use of paid leave for employees if the employee or a family member has been a victim of any act or threat of domestic violence, unwanted sexual contact, stalking, or human trafficking. And it applies to employers with 5 or more employees. It requires 40 hours per year of safe time or sick leave for victims of the covered crimes. Again, one where the on-site management may not realize this is a requirement and inadvertently violate the law in New York City. Vermont, on a statewide basis, provides time off for employees who are the victims of crime, as do many municipalities throughout the United States. So again, this is a topic that's worth checking in the jurisdictions in which you have operations. Another less common law, but one that may be gaining traction is the idea of employees who can request a temporary change in their work schedule up to twice a year due to a personal event. And that would include the need to provide care for a minor child or care recipient, to attend legal proceedings or a hearing for subsistence benefits, any circumstances that would be the basis for safe time or sick leave under the Earned Safe Time and Sick Time Act. So employees can alter their hours, reporting times, or locations for a limited period of time. This is sort of a novel approach, and again, New York is leading the way, but it remains to be seen how much traction this will get nationally. New York also has an enhanced dialogue regarding accommodations, employers being required to engage in cooperative dialogue regarding requests for reasonable accommodations for victims of domestic violence, individuals with pregnancy or related conditions, religious needs, or disabilities. So it expands the notion of the interactive process applicable under the Americans with Disabilities Act to other areas, and imposes the same obligation for a good faith interaction prior to denying a request. So yet another special provision in New York City that employers should be familiar with, because these, many of these areas would not be ones where there was a perception of a requirement to have some form of an interactive process. If you fail to engage in the dialogue, that would be considered an unlawful discriminatory practice in violation of the New York City human rights law. In Massachusetts, there's a requirement for veterans to receive paid or unpaid leave on Memorial Day or Veterans Day. If you have employees who are veterans, they're entitled to that day off in Massachusetts. And in Delaware, their version of the State WARN Act, which is the federal plant closing and mass layoff law, requires employers with 50 employees to provide 60 days notice to affected employees, the Delaware Department of Labor, and the Delaware Workforce Board, if there's going to be a mass layoff, plant closing, or relocation that will cause employment loss. So greater coverage than the federal WARN Act. And that brings us to our question and answer session. Let me see if we have received any questions. Okay, one moment while I through questions. Okay, first question is, our office and almost all of our employees are in one state. We have a few remote employees who work from their homes in other states, specifically Minnesota, Illinois, Arizona, and New Jersey. Do we use our homes? We use our home state laws for the employees or the laws for the state they reside or conduct work? The answer to that question is, in general, you would use the law that is the most favorable to the employee. And so if you are located in a state and the company is headquartered in a state with a requirement, that may be the law that is applicable. Or if the employee works in a state with a greater protection, then you would follow that law. Subject to, in some jurisdictions, there are a minimum number of employees in the jurisdiction in order to trigger coverage. But many states, such as New Jersey, do not have a minimum. So if an employer is covered because they have enough employees anywhere in the country, then the employees who work in New Jersey or who regularly receive assignments in New Jersey are covered by the New Jersey laws. We've received another question which says, personal sick time we already provide. And for example, in New York, it may be that the company's existing policy meets the obligation to provide the minimum amount of paid leave, and so that would not be in addition to, but it's prudent to make sure that the implementation and the requirements for the use of paid personal or sick time comply with the obligations of the New York paid time off, whether that's for victims or for sick leave, because it would be, in general and under federal law, permissible to have a greater requirement, for example, to take a medical leave if you're going to pay for it than would be required under the Family and Medical Leave Act. And so while this is not in addition to necessarily the leave that you're making available, ensuring that you are making it available in a manner that is compliant with New York or whatever state's requirements is necessary. A similar question to our first one, do the laws apply to employers that have an employee that may work remotely in any of the states, but our headquarters is located elsewhere? And again, many of the laws will apply to any employee within that state, even if there are only a few, and even if they are working remotely. And so the question would be whether the company is itself a covered employer as defined by the particular state law. I will believe those are all the questions. If we have any additional ones. Okay, that appears to be the end of the questions. If anyone has an additional question, I will be happy to take that, and we'll leave a little bit of time for that. Okay, we are getting some additional questions, so let me get to those. Bear with me for one moment, please. Okay. Okay. The next question, will the webinar be recorded and sent to the attendees afterwards? It is being recorded, but will not be automatically sent to the attendees. It will be available on our website, quarles.com, under the Labor and Employment Practice Group tab, Events section. Both the recorded program and the PowerPoints will be made available on that basis. The next question regarding school-related parental leave, how broad is the criteria for educational-related activities? That's depending on the state, it can be quite broad, and so to attend a parent-teacher conference, to participate as a volunteer in a class program, to attend a performance, quite broad in terms of how the activities are defined. Okay. Next question. Please expand on the ability to discuss compensation during interviews. Can we still ask what compensation would the applicant require? The answer to that specific question is yes. Asking for the applicant's expectation or requirement for salary is fine. Even in the states that have banned the history of salary questions or that subject from interviews. And that's actually the way that in those states it is preferred to be approached. And in those states, it is also permissible for the applicant to disclose their compensation if they are using it for the purpose of negotiating the salary level. The next question, how do we stay in compliance with all the laws? Attending a program like this is a good start. I would say you should make a list of the states and localities in which you have operations and review on a regular basis some of the compilations available for state law updates. So, for example, HR professionals are familiar with the Society for Human Resource Management, and there are also some paid services that will provide updates on additional state or local requirements. The specific question, how do we have a nationwide sales force, and again, how do we remain in compliance? And that would be the method. You really, if you have employees in every state, you may find that it's necessary to have someone dedicated to monitoring developments. Many nationwide employers have a compliance function specifically within the HR department that tracks the new legislation as well as the proposed legislation. You also can consider resources that are, again, available either with a membership in a professional organization or some other fee-based service such as Westlaw. Another question. Okay, here's the next question. What if the employer is in multiple states and has more than 50 employees? Does the Maryland disclosure of sex harassment allegations just for those in Maryland? or an aggregate of all their locations. And the answer to that is if you are a covered employer in Maryland, you would have to report, but only on the events that have taken place in Maryland. So you may be covered and you may not have very much to report. And so an additional question, is the presentation available to view again? And the answer is yes. It will be on our website, and you can both listen to the audio again, and you will have the PowerPoints available. Is there a common criteria that makes a company a covered employer in states? And the answer is yes. It is generally the number of employees, and it has nothing to do with the type of operation or the volume of business, but employing people in one of the states is the main criteria for determining whether there is coverage. And the states may have a minimum of a certain number of employees within the state in order for there to be coverage of some of these laws, or it may look to the company's total workforce and apply coverage just to the employees within that state if the employer reaches the minimum. So for many of the things we looked at today, there was a minimum of 50 employees. And so in many of the states, once you have 50 employees anywhere in the United States, you would be covered by that state's law with regard to employees who are working in the particular state. Right. A participant very helpfully noted that the requirement for California for the mandatory training for supervisors is 2 hours, as we said, and there's 1 hour of mandatory training for non-supervisory employees in California. Another question, in California, for school-related parental leave, is it required to be paid time off? And the answer is no. There are a number of questions that are similar to two that we already answered about a company being headquartered in one jurisdiction but have employees working in other states, and I think we covered that. Another question, if my U.S. parent company has around 300 employees throughout the U.S. and some numbers in different states, do the laws apply to each entity or just those with the number of employees at that site? And the answer to that is that depending on the relationship between the operating companies, some of the laws might apply regardless of it being a separate company, or they might not. A general rule is that to the extent the multi-company operations still have common control over day-to-day employment matters, then they would generally be considered a single entity. Different laws in different states use different tests for determining joint employment, right, or single employment or integrated employment. And so the watchword is who's making decisions about the day-to-day HR functions. And if that is centralized or common between one or more of the companies, you would add those numbers together, and then the employees in each of the companies would be considered to work for the company as a whole. So that would be where you might have 3 companies with altogether 55 employees, but no single company with 50. And depending on how the company is structured and managed, it could be a covered employer for all of the different entities, even though none of them individually employ enough people. Another question, if an employer in Washington, D.C. already offers paid time off in excess of the required paid sick leave law, do they need to make any changes to their time off program? And the question, the answer to that question is they should make sure that the procedures and requirements for obtaining their internal paid time off meet the requirements of the paid time off statute. You know, for example, if an employer said you must request time off in a certain amount of advance notice, you know, with a certain amount of advance notice, that may not be sufficient to comply with a particular state or locality's requirement. Question, how do we apply for SHRM FCP credits for attending? In the handout section of the webinar dashboard, you will see a form for HR organization self-reporting, and you can use that to report your credits. I see that we are now at 12 o'clock, and to be respectful of everyone's time, if you would like to, we'll end the webinar now. I will stay on the line to answer questions for a few additional minutes, but we will consider the webinar to be concluded at this point. Thank you very much for your participation. So for those who have remained, another question, FMLA requirements are 50 employees within a 75-mile radius of one location. Does this cover all employees in the U.S. If one location meets the guideline? The answer to that is no. Under the Federal Family and Medical Leave Act, an individual employee seeking leave must work in a location at which there are at least 50 employees within a 75-mile radius. So small location operations are not covered by the Family and Medical Leave Act. That is one of the driving forces behind the state enactments of paid or unpaid leave that are broader than that and would cover smaller location operations. So the answer is you may need to make leave available under a state law that is not required under the FMLA. Question, do you have any advice for Maryland sick and safe leave, specifically notifying employees about the benefit? That's something that you would want to include in your employee handbook and any periodic updates to that are either electronically distributed or posted. Another question, do the minimum wage laws apply to people who work on commission? And so under federal law, in order to be exempt from the minimum wage part of the Fair Labor Standards Act, for a commissioned person, they have to be qualified as an outside salesperson. And so if those requirements are met, then the federal minimum wage does not apply. Each of the states has a different, or potentially has a different way of looking at commission. And so that, I would say, is a technical question that is worth having reviewed on a state-by-state basis, because many states do not have as broad an exemption for commissioned salespeople as is available under federal law. Another question, are there follow-up presentations coming in the near future? We have a full schedule of webinars in the labor and employment area that will be coming out between now and over the next 6 months. And so I would invite you to look at the upcoming events listing to see the topics. I would anticipate that there will be another update on state laws within a year as things continue to develop at the state level. It's clear that that's where all the action is, and many employers are, as we've seen from the questions, headquartered in one location and with operations in many locations. There is a question, are there CPE credits available for CPAs? And I must tell you, I don't know the answer to that, but if you would, whoever asked that could send me an email, I will get you the answer to that. And I believe that is it for the questions. So once again, thank you very much, and I hope you make it a great day.